Disclaimer: the following report is based on current legal news developments and is provided for informational purposes only. It does not constitute legal, medical, financial, or official advice. All viewpoints expressed here are drawn from factual reporting and public statements. News is a record of events and commentary, not personal guidance. Any anecdotal stories or examples should not be treated as professional advice. From Today, Legal News Report. Topic 1. Voting Rights Showdown in Alabama from Today. Election season is in full swing in Alabama, and a high-stakes showdown over voting rights and redistricting is playing out in federal court. A group of Black voters and civil rights advocates have launched an urgent legal bid to preserve a court-drawn congressional map that they argue better represents minority communities. State officials, however, are pushing to reinstate an older 2023 legislative map that would reduce the number of Black majority districts from 2 to 1. The dispute centers on whether Black voters can continue to choose their preferred candidates in 2 of Alabama's 7 congressional districts, as they did under the current remedial plan. With primaries looming and ballots set to be printed within days, both sides are urging a panel of judges to rule swiftly. They acknowledge that any last-minute map changes now could disrupt election administration and sow confusion among voters, raising the stakes for a timely decision. This battle springs from a recent Supreme Court decision that fundamentally altered the landscape of federal voting rights law. In Louisiana v. Calais, the justices issued a landmark ruling that significantly weakened the Voting Rights Act's protections against racial gerrymandering, raising the legal bar for proving discrimination in district maps. Emboldened by that decision, Alabama's Republican-controlled legislature wants to discard a court-approved map that was put in place after extensive litigation. That remedial map created a second Black majority district, which had been used in 3 elections, and even led to the historic election of a Black Democrat, Shomari Figures, to Congress. State lawmakers argue that the High Court's new standards justify a return to their 2023 map, even though that plan was previously found unconstitutional for diluting Black voting power. Civil rights attorneys countered that the state's earlier map remains an illegal racial gerrymander, pointing to Alabama's long history of racially polarized voting and intentional discrimination in redistricting as evidence that the new map is needed for fair elections. During a tense hearing, the judges grilled Alabama's top election official about the feasibility of swapping maps so close to the primaries. Jeff Elrod, the state's elections director, conceded that reassigning voters to new districts under the 2023 plan would be an enormous logistical challenge. He had earlier told the court that such an overhaul could take up to 4 months, yet on the stand he suggested a crash effort, with extensive overtime, might compress the timeline to just a week. Elrod admitted rapid changes could risk serious errors and confuse voters, but maintained it was still possible if absolutely necessary. The plaintiff's attorney, Abba Khanna, argued passionately that even under the Supreme Court's stricter standard, Alabama's 2023 map is a blatant Section 2 violation of the Voting Rights Act and should remain blocked. The state's lawyer, Solicitor General Barrett Beaudry, insisted the new legal precedent forces the court to reevaluate all prior findings, claiming the plaintiff's experts improperly used race in drawing the remedy map. With no decision announced yet, Alabama's election officials anxiously await the court's ruling, knowing that whichever map is used could alter the course of the upcoming elections. Subtopic 1. The recent Supreme Court ruling Louisiana v. Calais significantly changed how voting rights cases like Alabama's are evaluated. In that late April decision, the court's 6-3 conservative majority narrowed the scope of Section 2 of the Voting Rights Act, VRA, making it much more difficult for minority voters to challenge electoral maps as racially discriminatory. Observers note that this decision, which was sharply criticized by civil rights advocates, effectively raised the standard of proof for establishing that a map dilutes minority voting power. Many fear it gives a green light for states to roll back minority representation. Buoyed by Calais, Alabama officials argue that their old 2023 map, previously struck down, might now pass muster under the new, stricter test. The plaintiffs in Alabama's case, meanwhile, warned that Calais gets vital VRA protections and that Alabama's actions will be a first test of the decision's impact. If the courts ultimately allow Alabama to reinstate its earlier map, the result could ripple to other states considering similar rollbacks of minority opportunity districts. Subtopic 2. Alabama's contested redistricting stems from a clash over the number of majority black congressional districts in the state. The state's 2023 legislative map contained only one majority black district out of 7, even though black Alabamians compose about 27% of the population. A coalition of black voters and civil rights groups sued, and a federal court ruled that the 2023 map was an illegal racial gerrymander that diluted black voting power. The court replaced it with a remedial map that included a second black majority district, giving black voters a fair chance to elect their candidates of choice. That court-drawn map was used in the 2024 election and led to the historic outcome of a black Democrat, Shomari Figures, winning a congressional seat. Now, after the Supreme Court's VRA ruling, Alabama's legislature is arguing that its older plan should be reinstated on the grounds that it is permissible under the revised legal standard. Civil rights advocates counter that the previous map's suppression of black voters was egregious and remains illegal, citing decades of evidence of racially polarized voting in Alabama. They maintain that removing the second black district would once again deny black communities fair representation, effectively reversing the progress made under the remedial map. Subtopic 3. One major complication in Alabama's redistricting fight is the extremely tight timeline for implementing any changes. If the federal panel were to allow a switch back to the older map, election officials would have to scramble to reassign hundreds of thousands of voters into new districts by a court-imposed deadline. Alabama's elections director, Jeff Elrod, testified that compressing that process into mere days or weeks would be a daunting logistical challenge. He admitted such an abrupt change could risk errors, like voters receiving incorrect ballots, and potentially undermine public confidence in the integrity of the election process. Plaintiffs argue these concerns further support keeping the remedial map, which has already been used successfully without incident. They also fear that switching maps could confuse voters and suppress turnout. Even state officials acknowledge the difficulties of an 11th-hour redistricting change, although they insist they would do their best to manage. The judges, aware of the looming deadlines, pressed both sides on how their proposals would affect election administration and hinted at the urgency of reaching a conclusion that the 2023 map illegally undermined black voting strength. They emphasized that even under the new Supreme Court precedent, the evidence of racially polarized voting in Alabama and the legislature's history of diluting minority power are overwhelming. Civil rights lawyer Abba Khanna argued to the court that reinstating the one black district map would undo a lawful remedy that has already proven its effectiveness by enabling black voters to elect their preferred representative in 2024. She asserted the state's old map was a blatant Voting Rights Act violation and should remain blocked. Her team contends that the remedial map followed neutral redistricting criteria and corrected the clear dilution of black votes that occurred under the legislature's plan. They also warned that allowing the state's reversal will send a dangerous signal to other jurisdictions that they can manipulate maps to exclude minority voters whenever judicial oversight is weakened. Essentially, the plaintiffs are asking the court to reaffirm that Alabama's black citizens are entitled to 2 fair districts and that nothing in Louisiana versus Calais changes the need for equality under the VRA. Subtopic 5. The state's attorneys vigorously dispute the notion that their actions are racially discriminatory, saying they are merely following the rule of law as reinterpreted by the Supreme Court. Alabama's legal team, led by Solicitor General Barrett Beaudry, insists that the evidence used to find the 2023 map discriminatory would no longer be considered valid under the new Calais standard. Beaudry contended in court that the plaintiffs' experts improperly used race to design the remedial district, an approach he says is at odds with the Calais decision's caution against overt race-conscious districting. The state argues that the federal court must start from scratch and give the legislature a second chance, instead of just relying on its prior findings and maps. They maintain the older map was drawn primarily based on traditional criteria, like maintaining county lines and communities of interest, and that any correlation with racial demographics was incidental. Alabama's position is that its 2023 plan was legitimate and only struck down under a now obsolete legal test. Reinstating it, they argue, would respect the legislature's authority and align with the Supreme Court's new guidance, whereas forcing a second black majority district would be an unlawful racial gerrymander under the updated legal framework. Subtopic 6. The broader political stakes of the Alabama redistricting battle are not lost on observers. The remedial two-district map gave Democrats a rare victory in the state and increased African American representation in Congress, if it is replaced by the legislature's original plan. That extra Democratic seat would likely revert to a Republican in future elections. Civil rights groups warn that reducing black representation in Alabama's delegation and the delegations of any other states if they follow suit could help the Republican Party maintain or expand its majority in the U.S. House of Representatives. Conversely, Republicans believe reinstating their favored map would correct what they see as unfair meddling by courts and restore what they consider a rightful political balance. This contest thus has implications beyond Alabama, as each party sees the handling of black voters' representation in the Deep South as potentially affecting the overall composition of Congress. The high-profile litigation underscores the interplay between law and politics. What looks like a technical legal question about district lines carries huge real-world consequences for state and national political power. Subtopic 7. The Alabama redistricting showdown and the court's handling of it will likely shape how other states approach their maps post-Calais. If Alabama's legislature prevails, it could embolden other states to revisit or try to scale back minority districts created under the Voting Rights Act. Louisiana, whose own case led to the Calais decision, is in a similar situation with courts considering the validity of its reconfigured congressional map. On the other hand, if the federal panel in Alabama sides with the plaintiffs and preserves the two-black district plan, it would signal that even under the Supreme Court's tightened standard, the most egregious gerrymanders will still be corrected. Several other states, including Texas, Georgia, and South Carolina, are grappling with their own redistricting challenges involving minority voting power. The Alabama case is being watched closely as a bellwether. As one voting rights advocate put it, this is a first test of the Supreme Court's new rules and how far states can go in reducing black representation before courts say no. The eventual outcome could either quell or encourage a wave of attempts to roll back minority voting influence across the country. Topic 2. Tulsi Gabbard resigns as intelligence chief from Today. Tulsi Gabbard, the U.S. Director of National Intelligence, has stunned Washington by announcing she will resign her position at the end of next month. Gabbard, a former Democratic congresswoman from Hawaii who joined President Donald Trump's administration as a Republican ally, cited her husband's serious health crisis as the reason for stepping down barely 1 year into her tenure. In a letter to President Trump delivered Friday, Gabbard explained that her husband has been diagnosed with an extremely rare and aggressive form of bone cancer, and she needs to devote her full attention to his care. The decision marks the end of a high-profile but relatively brief stint as the country's top intelligence official, one of the highest-ranking women in the Trump administration. Gabbard expressed gratitude to the president for his support and promised to facilitate a smooth transition to her successor. The First Lady and former White House Communications Director cited her family's needs above all else, emphasizing that the health emergency makes it impossible for her to continue in the critical national security role. Gabbard's departure follows a period of growing tension and differing views within the administration's national security team. As Director of National Intelligence, DNI, Gabbard is believed to have been increasingly marginalized in recent months, particularly regarding policy conflicts over the administration's handling of foreign wars. Gabbard, 42, built her career on a reputation as an anti-interventionist, critical of forever wars positions that sometimes clashed with the hawkish stance dominant in the Trump administration. Reports suggested she had been sidelined from key discussions about President Trump's decisions, including the controversial U.S. war with Iran and troop deployments in Europe. President Trump himself publicly noted that Gabbard's approach to questions like Iran's threat was a little different from his own policies, revealing a divergence in their views on military action. Gabbard also faced skepticism during her confirmation and tenure over past statements. She was questioned in Senate hearings about her sympathetic comments on Russia's perspective and her 2017 meeting with Syria's Bashar al-Assad, as well as her reluctance to label NSA whistleblower Edward Snowden a traitor. While supporters say she brought valuable transparency to the intelligence community, critics maintained that her independent streak made her a poor fit for the role in a regime that demands loyalty. President Trump responded to Gabbard's resignation announcement with a public display of support and an eye to continuity in national security operations. On his social media platform, Trump praised Gabbard's service, thanked her for her contributions, and wished her husband well in his battle with cancer. The president announced that Gabbard's principal deputy, veteran intelligence official Aaron Lucas, would take over as acting DNI when she steps down at the end of June. This swift move aimed to minimize disruption and send a signal of stability to the intelligence community. While some media commentators have speculated about behind-the-scenes disagreements over policy, and indeed Gabbard's resignation follows a period of reported factional strife, the administration is portraying her exit as purely personal and amicable. Gabbard herself has emphasized her gratitude to the president and her intent to ensure a seamless transition. It remains to be seen who will be nominated as her permanent successor and whether that choice will represent a shift in the ideological direction of U.S. intelligence leadership. Subtopic 1. Tulsi Gabbard's appointment as the nation's top intelligence chief was noteworthy for her unorthodox political journey. Once a Democrat who even sought her party's presidential nomination in 2020, Gabbard famously left the Democratic Party and endorsed Republican candidate Donald Trump in 2024, aligning herself with his America First foreign policy views. This dramatic shift, from progressive Democrat to a key figure in a Republican administration, is without recent precedent in U.S. politics. Gabbard's support from Trump and subsequent appointment as DNI symbolized her political realignment. She also made history as one of the highest-ranking women of color in the national security apparatus. Her ideological transformation earned her fervent support from some on the right, who appreciated her criticism of Democratic leadership and opposition to overseas interventions. But it also drew skepticism from those who questioned her qualifications and consistency. Her tenure as DNI thus exemplified the surprising alliances forged in the Trump era, as well as the sometimes uneasy accommodation of divergent foreign policy philosophies within one administration. Subtopic 2. Gabbard's resignation comes against the backdrop of escalating foreign policy tensions that put her at odds with some colleagues. In particular, the administration's war in Iran, which began earlier this year, highlighted a gulf between Gabbard's non-interventionist instincts and the hawkish leanings of the White House. Gabbard had long opposed what she considered unnecessary military interventions, dating back to her time in Congress when she criticized U.S. involvement in Syria and other conflicts. As the crisis with Iran escalated, reports suggested Gabbard was cut out of key strategy sessions and that her caution about expanding U.S. military commitments placed her at odds with more hardline voices inside the administration. President Trump himself acknowledged differences. In a March press conference, he remarked that Gabbard's stance on what constitutes an imminent threat from Iran was a little different from his own. The rift became more visible when Gabbard's personal aide and deputy DNI Joe Kent resigned abruptly in protest over the Iran conflict, apparently feeling that Gabbard's counsel was being ignored. This context of internal friction, combined with her husband's health emergency, likely contributed to Gabbard's decision to step aside. Subtopic 3. Key to Gabbard's decision was the health crisis facing her family, particularly her husband Abraham Williams' fight against an extremely rare bone cancer. In her resignation letter to the president, Gabbard described the urgency of the situation, calling her husband's condition life-altering and stressing her need to be by his side full-time. If I have learned anything from my tenure, it's the irreducible value of family and time, Gabbard wrote. Fellow officials and lawmakers across the political spectrum offered public well wishes, acknowledging the difficulty of her choice. Many can empathize, as her departure highlights a dimension of leadership we rarely see publicly. Senior officials sometimes must step away from high office due to personal and family health crises. Gabbard's statement resonated with many ordinary Americans balancing work and caregiving, demonstrating how the demands of service can intersect with the challenges of personal life. Colleagues said her prioritization of family was admirable, even as her departure leaves a gap in the national security apparatus. Subtopic 4. President Trump's response to Gabbard's resignation was supportive and focused on selecting a successor who shares his worldview. On his social media, Trump praised her as a patriot and credited her for increasing transparency in the intelligence community, one of Gabbard's stated goals as DNI. By immediately naming Aaron Lucas as acting DNI, the president ensured continuity. Lucas, a veteran intelligence officer and Gabbard's top deputy, is expected to maintain the office's direction until a permanent replacement is named and confirmed by the Senate. The quick transition also signaled the White House's desire to avoid any gaps at the helm of the intelligence community at a time when multiple global crises demand attention. The administration has not yet indicated who will be nominated for DNI long-term, though speculation ranges from other Trump loyalists within the intelligence agencies to outside figures known for tough stances on China and Iran. Any nominee is likely to face rigorous questions from senators given the sensitive nature of the role. Subtopic 5. Reaction to Gabbard's exit has been largely respectful across the political spectrum, although not without some partisan sniping. While President Trump and many Republicans praised Gabbard's service, some prominent Democrats and liberal commentators were less generous. For instance, a Democratic lawmaker, Representative Adam Schiff, sarcastically tweeted that Gabbard's resignation was her only positive contribution to national security, implying that her time as DNI did not benefit the country. Such remarks have drawn criticism from Gabbard's defenders and even some moderates, who see them as unduly harsh at a time when the issue is her husband's health, not politics. On the other hand, former officials from the intelligence community have offered public kudos to Gabbard and empathy for her personal decision. The varied responses underscore the polarizing effect Gabbard has had. Even her departure, under tragic circumstances, has become fodder for partisan commentary from some quarters. Notably, no comment on the resignation or Wolf's insinuations has yet come from the First Lady's office, reflecting perhaps a desire to keep the focus on Gabbard's personal reasons for leaving. Subtopic 6. Gabbard's tenure as DNI, though ending prematurely, was not without achievement and controversy. During her time in office, she championed increased transparency in the intelligence community, releasing declassified summaries of certain surveillance programs and emphasizing the importance of rebuilding public trust. She also pursued an internal review of how intelligence agencies could avoid what she called politicization and the misuse of intelligence, one of the priorities that attracted her to the job given her outspoken stance against the so-called deep state. But her independent streak sometimes rankled others in the administration. Some in the national security establishment were wary of her prior ties to figures like Assad and her reluctance to fully embrace the U.S.'s hardline approach to adversaries like Iran. Those controversies never fully subsided, which may have contributed to Gabbard's limited influence in shaping policy. Still, admirers say she set an example by speaking her mind and trying to ensure intelligence was not manipulated for political ends. Subtopic 7. With Gabbard's resignation, attention turns to the future of the DNI position and how it might shift under new leadership. Some analysts speculate that her departure will allow President Trump to choose an intelligence chief more aligned with the administration's hawkish consensus, someone without the non-interventionist leanings that made Gabbard an outlier. Others caution that radical changes aren't likely because the intelligence community has its own institutional inertia. Meanwhile, The immediate concern is maintaining continuity in national security operations as a series of key global challenges, from a potential war escalation in the Middle East to simmering tensions with China and Russia, demand steady intelligence leadership. While Gabbard's exit is openly linked to personal reasons, some perceive it also helps remove a potential friction point within the administration. Ultimately, her replacement's identity and orientation will be revealed when President Trump nominates a new director of national intelligence. And that person's confirmation process will indicate how this storied position will evolve in the remaining years of Trump's second term. Topic 3. Google fights antitrust verdict on search dominance, from Today. In Washington, technology giant Google is pressing an appellate court to overturn a landmark ruling that found it maintained an illegal monopoly over the internet search market. On Friday, Google filed a lengthy brief urging the U.S. Court of Appeals for the D.C. Circuit to throw out a federal judge's decision that the company violated antitrust laws. Last year, after a closely watched trial, U.S. District Judge Amit Mehta concluded that Google had used exclusive contracts and technical tactics to unlawfully preserve its dominance in search and search advertising since 2010. In a ruling favored by the Justice Department and a coalition of state attorneys general who had sued the company, Judge Mehta imposed a series of remedies aimed at curbing Google's market power and fostering competition. Those remedies stopped short of breaking up the company but required, among other things, that Google share parts of its search data and technology with rival search companies. Google immediately appealed, and it is now arguing that the judge's findings were legally flawed and threatened to punish what it views as simply a successful business model. The case is part of the most significant U.S. government challenge to a big tech company's power in a generation. In its appeal, Google contends that the trial court misapplied antitrust law by treating its business success as proof of wrongdoing. The company argues that its overwhelming market share, over 80% of U.S. search queries by 2009, was earned through superior technology and consumer preference, not illegal tactics, and that its brand became synonymous with online search simply by being better than alternatives. Far from stifling competition, Google asserts that its arrangements with browser companies were non-exclusive. In its view, partners like Apple, which makes the Safari browser, and Mozilla, which makes Firefox, chose Google Search as the default because it was simply the best, not because rivals were unfairly shut out. Google's brief points out that those partners could still feature rival search engines if they wanted, so it denies any actual foreclosure of competition. To Google's thinking, the trial judge blurred the line between aggressive but legal business strategies and truly anti-competitive behavior. It brands the lower court's conclusions as a fundamental error of antitrust law that punishes a company for excelling. As part of its appeal, Google is also challenging the strict remedies Judge Mehta ordered, which the company has called onerous and harmful to innovation. Rather than a forced breakup of its businesses, a step the court declined, the trial judge required Google to share aspects of its search infrastructure, such as its comprehensive search index and certain search data, with competitor companies and to accept oversight by a 5-member technical committee. Google contends these measures effectively compel it to help its rivals, creating what it dismisses as ersatz, or artificially manufactured competition. The company also argues that even completely new players like OpenAI, which launched generative AI search tools not long ago, could unfairly piggyback on Google's decades of innovation by exploiting the mandated data sharing. Additionally, Google has been sparring with the DOJ over access to competitor data submitted to the technical committee, claiming that being denied full visibility into that data would violate its due process rights. Industry watchers say this case could reach the Supreme Court, and its outcome may have sweeping implications for the tech sector, potentially reshaping the future of antitrust enforcement for big tech companies. Subtopic 1. The search antitrust case against Google is among the most significant in the tech industry since the Microsoft antitrust trial in the late 1990s. In that era, a federal judge initially ordered Microsoft to be broken up for bundling its Internet Explorer browser with Windows, a remedy later overturned on appeal in favor of a lesser settlement. Google's legal team has drawn parallels to the Microsoft case, arguing that just as the courts did not ultimately break up Microsoft, the remedies imposed on Google are too extreme. They maintain that compelling data sharing or other structural changes could harm innovation and go beyond addressing any competitive harms. The DOJ, however, sees Google's dominance as akin to Microsoft's past behavior, using its market power, particularly through default search engine deals and bundling on mobile devices, to stifle competition. The Microsoft trial ended in a settlement, and some commentators have speculated that Google may ultimately reach a compromise with regulators. There is also the possibility of new legislative action. The momentum to curb big tech has grown since the Microsoft days, and Congress has eyed measures to better equip enforcers to address platform monopolies. Whichever way the courts rule on Google's appeal, the case represents a pivotal moment in modern antitrust, either reinforcing or curtailing new efforts to limit big tech's power. Subtopic 2. One pillar of the government's case against Google involved its multi-billion-dollar contracts with browser developers and smartphone makers to secure default search engine status. Judge Mehta's original ruling emphasized that Google's deals, such as paying Apple an estimated $12 billion per year to make Google the default search on iPhones and iPads, effectively locked out competitors like Bing by controlling how users access search. Similarly, Google ensured that its search engine came pre-installed on Android smartphones and was the default search in the Firefox browser, further cementing its dominance. These deals meant that the vast majority of Internet users reached Google without actively choosing to, reinforcing its monopoly share. Google contends these deals were just legitimate agreements where partners selected the best service, Google, to enhance user experience on their devices. But the Justice Department argued such default arrangements discouraged consumers from trying alternatives and therefore constituted anti-competitive behavior. The way to search engines' default status carries in user choice was central to Meta's finding that Google's conduct illegally maintained a monopoly, a finding now under review by the appeals court. Subtopic 3. Bundling was another key element of the case. Judge Mehta found that Google leveraged its other products, like Android OS and the Chrome browser, to advance its search dominance by requiring hardware and software partners to include Google's search engine in their products. Device manufacturers who wanted to pre-install Google's Play Store on Android phones, for example, had to agree to also set Google as the default search engine on those devices. Meta ruled that these tying arrangements helped thwart competition by making it more difficult for any rival search engines to gain users. Google contends that these integration deals are standard industry practice that benefit consumers by offering integrated services for free, not nefarious schemes to harm others. But the judge disagreed and saw them as boosting Google's market power beyond what merit alone would have achieved. Taken together with the default browser deals, these bundling requirements were found to be part of a coordinated strategy to maintain Google's chokehold on the search market in violation of antitrust law. Subtopic 4. If Google's appeal fails and Judge Mehta's remedies remain in place, it would significantly alter how the company does business and possibly hand an advantage to rivals. Per the existing order, Google would be required to open up key parts of its search ecosystem to competitors. For example, one remedy mandates that Google share some of its search index data with smaller search companies, enabling them to deliver more comprehensive results. Google argues that forcing such data sharing essentially subsidizes its rivals and could even raise serious user privacy issues. Another remedy involves an oversight body, the Technical Committee, monitoring Google's compliance, which the company claims deprives it of due process and could expose its internal business secrets to competitors. If the remedies survive on appeal, search engines like Bing or smaller players such as DuckDuckGo could benefit by gaining access to what they call Google's search pipeline, a trove of information and technology that has given Google a leg up for decades. Tech industry experts note that the search landscape might become more competitive if Google has to operate on a more open model. Conversely, if Google wins and these remedies are thrown out, it will be seen as a significant setback for regulators trying to rein in big tech through the courts. Subtopic 5. Competitors and industry observers are carefully watching the Google case, as they have a stake in the outcome. For rival search engines like Microsoft's Bing, A final decision upholding Meta's ruling could present a golden opportunity. If they could gain access to Google's index or embed their search results with Google's data, they might significantly improve their own capabilities and close the gap with Google's quality and speed. Alternatively, if Google's appeal succeeds, it might embolden other dominant tech firms to double down on similar tactics, like exclusive deals or bundling, without fear of strict legal remedies. The appeal is seen by many as a litmus test for how far courts will go to intervene in tech giants' business practices. The stakes are also financial. Investors have been closely tracking the case, as a loss for Google on appeal could impose costly compliance obligations and potentially create openings for competitors that might chip away at Alphabet's market dominance. A win for Google, meanwhile, could reassure markets that big tech's business models remain largely safe from radical judicial intervention. Subtopic 6. Overhanging this legal confrontation is the widespread anticipation that it could end up at the Supreme Court. Both the DOJ and Google have strong incentives to fight aggressively. For Google, the appeal is about preserving its business model, and for the DOJ and allied states, it's about upholding one of the most significant antitrust victories against big tech to date. If the appeals court rules against Google, the company will almost certainly petition the Supreme Court. Conversely, if Google wins here, the DOJ and states could push the issue to the High Court, arguing that the Supreme Court has not heard a major monopolization case in decades, so if this case reaches them, it could yield a landmark decision that defines antitrust enforcement in the digital era. The possibility of Supreme Court review adds yet another layer of importance to a case that is already being closely watched by regulators, technology companies, and consumers alike. Subtopic 7. The broader regulatory climate in which Google's appeal is unfolding has grown increasingly hostile to big tech's market power. Across the political spectrum, there is rare unity in seeking stricter enforcement. The Trump administration, continuing an effort begun in the late Obama years, has spearheaded multiple antitrust actions against tech giants, and state attorneys general of both parties have joined in. Apart from this search monopoly case, Google separately faces a DOJ suit over its digital advertising dominance, and the Federal Trade Commission, FTC, is reportedly preparing a case against Amazon's business practices. Meanwhile, bipartisan proposals in Congress would update antitrust laws to better address modern digital markets. For big tech firms, these legal wins of change signal that the era of light-touch regulation may be ending. The outcome of Google's search antitrust battle will either reinforce or hamper that momentum. A government win could embolden regulators and lawmakers to pursue even more aggressive measures, perhaps even structural changes. While a Google win might slow the push for sweeping actions by suggesting that existing law isn't agile enough to tackle tech monopolies without new legislation. Topic 4. Trump slush fund faces legal challenge from today. In Alexandria, Virginia, a group of former government officials and advocacy organizations have filed a lawsuit seeking to dismantle the Trump administration's newly established $1.8 billion anti-weaponization fund. The plaintiffs, who include a former federal prosecutor, a college professor, a pro-choice healthcare association, and a democracy watchdog group, claim that the fund is an illegal use of taxpayer money designed to benefit President Trump's political allies. The unusual fund, announced by the Justice Department on May 19th, was created to compensate individuals who claim they were unfairly targeted by federal investigations during prior Democratic administrations. A category that includes many of Trump's own supporters, including people he has pardoned. The fund's creation was made possible by a legal settlement between Trump's allies and the IRS, after IRS employees were found to have leaked some of Trump's tax records. Nearly $1.8 billion in settlement funds was allocated to this new program at the DOJ's discretion. Critics, including members of Congress from both parties, immediately labeled it a slush fund that would funnel public money to political cronies. The new lawsuit, filed Friday in federal court, asks a judge to halt the program and declare it unconstitutional. In their legal challenge, the plaintiffs lay out multiple arguments for striking down the anti-weaponization fund. They contend the program usurps Congress's power of the purse by creating a massive payout fund without legislative approval, violating the constitutional separation of powers that grants spending decisions to Congress. Additionally, the suit accuses the fund of violating administrative law, asserting that the Justice Department unveiled it without following required rulemaking procedures, such as a public notice and comment period under the Administrative Procedure Act, APA. The complaint also raises First Amendment issues, charging that the fund engages in viewpoint discrimination. It pays out only to those who claim persecution by Democratic-led justice agencies and excludes individuals targeted by Republican administrations. According to the plaintiffs, this is akin to the government favoring one political faction and one set of beliefs over another, which violates constitutional norms. The unprecedented nature of the program, including using taxpayer money to compensate people convicted of crimes like the January 6th Capitol attack, bolsters the plaintiffs' argument that it serves no legitimate public purpose. They are seeking an immediate injunction to freeze the fund and ultimately a permanent order shutting it down. Political backlash to the fund has been swift and intense. A bipartisan group of House members introduced legislation to block any federal spending for the anti-DASH weaponization efforts, describing it as a brazen attempt to use the public treasury for a narrow, partisan objective. The Justice Department has defended the fund by pointing to a past settlement funding program, specifically a 2011 Agriculture Department settlement, the Keep Siegel case, that created a trust for Native American farmers, as precedent. But critics say that analogy doesn't hold. In Keep Siegel, payouts were to compensate a proven pattern of discrimination, while the Anti-Weaponization Fund is paying alleged victims of what the plaintiffs call unsubstantiated grievances aligned with the president's political narrative. In public discussions, even some local Republican leaders have joined the outcry. For example, New Haven, Connecticut's mayor joined the lawsuit, decrying that his city's taxes would help reimburse political cronies and criminals. The controversial fund has already complicated a major budget bill's passage in the Senate, with Republican senators delaying a vote over concerns the bill would indirectly fund the program. A federal judge's decision on this lawsuit will likely have significant implications for executive authority and public trust in impartial justice going forward. Subtopic 1. The plaintiffs who filed the lawsuit come from diverse backgrounds, illustrating how widely the Anti-Weaponization Fund has raised alarm. One is Andrew Floyd, a former federal prosecutor who helped prosecute January 6th rioters. He argues he is now forced to watch many of those same participants stand to receive tax-funded payouts as a reward for their crimes. Another plaintiff is Jonathan Caravello, a university professor who was charged by Trump's DOJ after protesting an immigration raid, but later acquitted. He contends that the fund only helps people on one side of the political spectrum. Also joining the suit are the National Abortion Federation, which notes that anti-abortion activists might claim funds, while pro-choice activists could not, and Common Cause, a nonpartisan watchdog group. Additionally, the city of New Haven, Connecticut, under Mayor Justin Elicker, signed on due to fears that local taxpayer dollars could be diverted to this fund rather than vital services. This broad coalition asserts that the fund sets a dangerous precedent, using federal resources to reward a narrow, politicized group over others, and is asking the court to bring an end to it before any money is dispersed. Subtopic 2. The Anti-Weaponization Fund itself was created as part of the Trump administration's narrative that government agencies have been weaponized against conservatives, a key theme of Trump's political messaging. The Justice Department announced it would use about $1.776 billion recovered from an unrelated settlement, the IRS tax leak mentioned above, to compensate people who believed they were victims of politically motivated investigations by Democratic administrations. Potential recipients include individuals charged in the Russia investigation, targets of FBI probes during the Obama/Biden years, and those prosecuted for participating in events like the January 6th Capitol attack whom Trump considered unjustly persecuted. Critics, including the plaintiffs in the current case, view the fund as a thinly veiled political patronage program, effectively using public funds to pay off individuals who are loyal to Trump or further his narrative. It's seen as unprecedented. Never before has a president allocated such a vast sum in a way that seems explicitly designed to compensate his supporters for legal troubles. This is why detractors have labeled it a slush fund, implying money used at the executive's whim without proper oversight or neutral criteria. Subtopic 3. The legal arguments against the fund are multifaceted. The Constitution gives Congress, not the executive branch, the authority to appropriate federal funds, and the plaintiffs argue this fund violates that principle by spending nearly $1.8 billion in taxpayer money without congressional approval. Additionally, since the DOJ did not engage in a formal rulemaking process, the plaintiffs claim the creation of the fund violates the Administrative Procedure Act, APA. Essentially, that the DOJ cannot simply create a new benefit program unilaterally, especially one with such broad discretion and no public input. Lastly, and perhaps most strikingly, the complaint argues the fund amounts to viewpoint discrimination under the First Amendment and equal protection principles. By design, only those who claim they were targeted by Democratic-led agencies are eligible for payouts. Someone targeted by Trump's DOJ, like a progressive activist or his political opponent, is explicitly barred. This has been likened to the government using public funds to favor one political viewpoint. If the court finds any of these arguments compelling, it could declare the fund illegal on constitutional grounds and shut it down. Subtopic 4. The ramifications of the Anti-Weaponization Fund have already rippled beyond the courtroom, influencing the legislative branch and public discourse. Mere days after the fund's unveiling, its inclusion in a must-pass appropriations bill derailed Senate negotiations. Senate Republican leaders left Washington for the weekend rather than move forward with a DOJ funding package that included the fund, reflecting divisions even within Trump's party. On the other side, many conservatives passionately defend the fund as righting what they see as wrongs inflicted on Trump allies by what they term a biased judicial system. This dichotomy underscores how the fund, and the lawsuit challenging it, lie at the intersection of law and politics. If the lawsuit succeeds in stopping the fund, it will validate concerns about politicization and set a precedent that even a president cannot allocate resources in this manner. If it fails and the fund proceeds, it might embolden similar efforts of executive largesse for political loyalists and could even inspire legislative reform to clarify constraints on such executive funds. The judge's upcoming decision will be a milestone in defining the boundaries of executive power and the role of courts in policing potential abuses. Subtopic 5. An interesting comparison raised by the DOJ is the Keep Siegel Settlement Trust, which they argue is akin to the Anti-Weaponization Fund. In Keep Siegel, Native American farmers who had suffered documented discrimination by the USDA were awarded damages, and leftover settlement funds were placed in a trust to benefit Native farming causes. The DOJ asserts that if that settlement trust was legal, so is the Anti-Weaponization Fund. Plaintiffs and many legal analysts see a stark difference. The Keep Siegel Trust was part of a court-approved settlement to remedy proven wrongdoing, systematic discrimination, whereas the Anti-Weaponization Fund is not based on any adjudicated violations by the government. Furthermore, the Keep Siegel Trust had clear guidelines and oversight for distributing funds. By contrast, critics say the Anti-Weaponization Fund lacks transparency and objective criteria. The DOJ has not fully explained how claims will be validated, leading to fears it could dole out money at the whim of political actors. This difference between a remedial class action settlement and a unilateral executive fund is likely to be a focus of the legal debate and could heavily influence how the court distinguishes between the two. Subtopic 6. Enrique Tarrio, one of the people who might benefit from the Anti-Weaponization Fund, has already drawn attention for boasting about the money he stands to receive. Tarrio, the former leader of the Proud Boys, was convicted of crimes stemming from the Capitol insurrection and sentenced to 22 years in prison, but then was pardoned by President Trump. In a post online following the DOJ announcement, Tarrio claimed he should receive between $2 to $5 million from the fund as compensation for what he calls unjust persecution. His public eagerness for a payout has fueled opponents' arguments that the fund is simply a political rewards program that encourages impunity for criminals. Trump supporters, however, see Tarrio's statements as proof that the fund's raison d'etre is legitimate, that people like Tarrio were politically targeted and deserve to be made whole. Tarrio's boldness, which many Americans find shocking, vividly illustrates why this fund has become such a flashpoint. It's extremely unusual for convicted felons to openly discuss receiving taxpayer money for their ordeal, and that reality has deeply polarized public opinion over the fund's propriety. Subtopic 7. Looking ahead, the legal and political fate of the Anti-Weaponization Fund remains uncertain. If the court grants an injunction or rules the program illegal, President Trump could face pressure to find alternative means to assist his allies, or to scale back his rhetoric around weaponization as a public policy rationale. Alternatively, if the fund is upheld, it may continue to fuel criticisms of politicization at the Justice Department and possibly prompt legislative pushback or attempts by other states to block it. The Justice Department has already vowed to appeal any ruling against the fund, meaning the fight could extend to higher courts, potentially even reaching the U.S. Supreme Court given the significant constitutional questions. Meanwhile, would-be recipients are likely to file their claims promptly as the legal battle plays out, which could complicate things further if payouts begin before litigation concludes. Ultimately, how this conflict is resolved could have a lasting impact on the interplay between executive authority and the judiciary and serve as a precedent for how American democracy deals with perceived abuses of power at the highest levels. Topic 5. Alabama judge slams vindictive prosecution of deported immigrant, from Today. A federal judge in Tennessee has taken the extraordinary step of dismissing a criminal case against an immigrant defendant, ruling that the Trump administration targeted him in a vindictive prosecution after he fought his own deportation and won. U.S. District Judge Waverly Crenshaw, Jr., sitting in Nashville, threw out human smuggling charges against Kilmar Abrego Garcia, a 37-year-old Maryland man originally from El Salvador, citing overwhelming evidence that the case was brought in retaliation for his successful challenge to a deportation order. Abrego had been deported to El Salvador in early 2025, despite a court ruling blocking his removal. After the Supreme Court intervened and forced the government to return him to the U.S., the Justice Department quickly secured an indictment against him for conspiracy to transport undocumented immigrants. Judge Crenshaw noted that the DOJ had shown little interest in prosecuting Abrego until he embarrassed the administration by winning his case to come back. The judge's sharply worded Friday decision, calling the prosecution vindictive, selective, and in violation of the Fifth Amendment, marks a rare rebuke to the DOJ's exercise of its prosecutorial discretion. Abrego's saga is complex and unprecedented, intertwining immigration law and criminal prosecution. He was deported from the U.S. in March 2025, after an immigration raid in Maryland resulted in his removal to a harsh mega-prison in El Salvador. Those attorneys fought the removal in court, and in a highly unusual move, a federal judge, later affirmed by the Supreme Court in January 2026, ordered the government to bring Abrego back to the United States, ruling his deportation to El Salvador was illegal. The DOJ's response to Abrego's return was to resurrect a dormant inquiry into a November 2022 incident in Tennessee, a traffic stop where Abrego had been found transporting undocumented migrants, but initially wasn't charged. Federal prosecutors quickly indicted him last month on immigrant smuggling charges and detained him. Judge Crenshaw's review of communications revealed that a top DOJ official made the case a top priority right after the court's order to bring Abrego back, suggesting a retaliatory motive. The judge concluded that the timeline created a presumption of unconstitutional vindictiveness, which the government failed to counter with legitimate reasons for why it reopened the case when it did. The judge's decision to dismiss the charges against Abrego is a stinging rebuke to the Justice Department. Crenshaw, an Obama-appointed judge, implied that the prosecution was an abuse of power aimed at punishing a critic of the administration's immigration policies. Federal courts rarely find prosecutorial vindictiveness, so this ruling is legally significant. highlighting the judiciary's willingness to check what it views as retaliatory prosecution. The Justice Department blasted the dismissal, with a spokesperson labeling Judge Crenshaw an activist who is interfering in immigration enforcement and promising an immediate appeal. Immigrant rights advocates, however, celebrated the decision as a triumph of due process. They argue it sets a precedent that the Trump administration cannot misuse criminal prosecutions to get back at immigrants who challenge their removals. If upheld on appeal, the ruling will reaffirm that even national law and order initiatives have limits when they collide with the Constitution's guarantee of fair and impartial justice. Subtopic 1. Vindictive prosecution is a legal term signifying a prosecutor's improper motive and demonstrating it is notoriously difficult. Under Supreme Court precedent, defendants must prove that prosecutors sought charges to punish them for exercising a legal right, like appealing a conviction or filing a complaint. In practice, courts are very reluctant to second-guess prosecutors' motives except in clear-cut cases of retaliation. Abrego's attorneys argued that the DOJ's decision to charge him in 2026, after previously declining to do so, was solely because he had challenged his deportation and embarrassed the government. They cited the striking sequence of events, months of silence on potential charges, then an indictment just weeks after a court forced his return. Judge Crenshaw agreed the timing was too conspicuous and found that the government offered no credible alternate explanation, upholding a presumption of vindictiveness. This rare finding sends a strong message that even federal officials can be called out if they wield their power to punish someone for winning in court. Legal experts say such rulings are unusual and illustrate that how the government exercises its discretion can be subject to scrutiny if the facts are egregious enough. Subtopic 2. Abrego's case saw unprecedented involvement by the U.S. Supreme Court in an individual deportation dispute, a factor that may have influenced the vindictive prosecution finding. Typically, immigration removal cases don't reach the Supreme Court, let alone result in an order to bring someone back to the country. The Supreme Court's decision to uphold a lower court's order returning Abrego to the U.S. was already a critical moment, underscoring how other courts believed his rights had been violated. With that backdrop, the subsequent DOJ indictment, only 11 days after Abrego's return, appeared highly suspect to Judge Crenshaw and others. This interplay of courts and executive action signals that immigration enforcement has increasingly become a tug-of-war between the judicial and executive branches. The Supreme Court's willingness to step in for Abrego may have emboldened the Tennessee judge to closely scrutinize the prosecution's motive. It also casts a spotlight on the otherwise secretive collaboration between the U.S. and El Salvador, which had sent Abrego to a high-security prison notorious for harsh conditions. A fact noted by the judge as part of the context that suggested a punitive mindset by authorities. Subtopic 3. Kilmar Abrego Garcia's immigration and legal odyssey illustrates how far the Trump administration has been willing to go in its quest to remove certain non-citizens. After his 2022 traffic stop in Nashville, Abrego wasn't charged, but he was placed in immigration proceedings due to suspected involvement in smuggling, a charge he denies. During those proceedings, his attorney argued that Abrego would be targeted by gangs if deported to El Salvador. An immigration judge agreed and forbade his removal, but the order was ignored in March 2025 when Abrego was loaded onto a plane and sent away. For nearly a year, Abrego languished in a Salvadoran megaprison amid violent criminals. During that time, his lawyers contended that his deportation was illegally executed and filed a habeas corpus petition in Maryland. After months of legal wrangling, a judge ordered Abrego returned. His case became emblematic of the administration's unyielding stance on immigration. Even those with pending protections or asylum claims were aggressively pursued and removed. Now that he is back and his criminal case dismissed, Abrego's story stands as a rare example of an immigrant firmly pushing back and prevailing against the system on multiple fronts. Subtopic 4. The Justice Department is already voicing strong objection to the Nashville ruling and is set to appeal to the Sixth Circuit. A DOJ spokesperson called the decision wrong and dangerous, arguing that it lets a defendant accused of serious immigration offenses off the hook. The department contends that the evidence justified a smuggling charge and that the prosecution was proper, not malicious. DOJ officials warn that the ruling might embolden others to claim their prosecutions are retaliatory and hamper law enforcement. By contrast, immigration law scholars have praised the decision, noting that without judicial oversight, the executive could potentially retaliate against individuals who challenge it, leading to a chilling effect on the exercise of legal rights. They assert that what the judge did was uphold the idea that no one, not even federal prosecutors, is above the Constitution. As the case moves to the appellate level, it will force higher courts to weigh the balance between prosecutorial discretion and protections against punitive government action, potentially providing a framework for similar cases in the future. Subtopic 5. Some legal experts draw parallels between Abrego Garcia's case and that of another high-profile immigration-related dispute involving an activist LPR named Mahmoud Khalil. Khalil's case, in the Third Circuit, deals with whether a green card holder can be detained and deported for participating in protests, raising fundamental questions about free speech for immigrants. Khalil's legal fight, which he lost in a narrowly divided appellate decision, has been cast by many as a crackdown on dissent using immigration powers. In both Abrego and Khalil's situations, critics accuse the Trump administration of stretching immigration enforcement to silence or punish those it perceives as adversaries. The big difference is in how courts responded. Abrego's prosecution was shut down due to a straightforward timeline evidencing retaliation, whereas Khalil's detention was allowed to continue as his activism case is built on more nuanced circumstances. Still, taken together, the two cases highlight the struggle between the Trump administration's broad interpretation of immigration law to serve political ends and the role of the judiciary in preserving individual rights. As Khalil's lawyers plan to petition the Supreme Court, it's clear that conflicts at the intersection of immigration policy and constitutional protections are far from over. Subtopic 6. As unprecedented as Abrego Garcia's case may be, his example could have a ripple effect on other legally embattled immigrants who believe they are being targeted or retaliated against. Immigration attorneys across the country have been following his case closely, and they say it has already influenced how they approach defenses for clients in similar predicaments. For instance, some lawyers representing immigrant activists or others who speak out against the administration's policies now say they will monitor for signs of punitive action by authorities to use as evidence, citing the Abrego decision. The ruling could encourage more detainees and defendants to raise claims of selective or vindictive prosecution in their own cases, though proving such claims remains very challenging without clear evidence like the kind uncovered in Abrego's situation. Additionally, it could provide a deterrent to federal and local agencies from pursuing reprisals, knowing courts have shown a willingness to intervene in egregious cases. Ultimately, the effect of Judge Crenshaw's decision will hinge on whether it stands on appeal, a question that may not be answered until the appeals court reviews the case later this year or next. Subtopic 7. Big picture, Abrego Garcia's and Khalil's cases together illustrate the limits of executive power and the evolving role of the judiciary in immigration matters. The Trump administration has pursued unprecedented measures, from negotiated third-country detention agreements to reviving old cases, to curb both illegal immigration and dissent. Courts are increasingly being asked to step in, and their responses have varied, from backing the executive's broad latitude, as in Khalil's scenario, to pushing back firmly, as with Abrego. These cases are shaping a new body of law at the crossroads of immigration enforcement and constitutional rights. Observers on both sides of the immigration debate agree that more such clashes are on the horizon, especially as Trump's second term intensifies its enforcement. How the courts define boundaries on retaliatory enforcement will have lasting implications not just for immigrants like Abrego and Khalil, but for the balance of power between the government and individuals in our democracy. Topic 6. Author's preemptive suit versus Melania Trump dismissed, from Today. A federal judge in New York has dismissed author Michael Wolff's preemptive lawsuit against First Lady Melania Trump, ruling that his claim was an improper attempt to gain a courtroom victory before she even sued him. Wolf's highly unusual suit sought a declaratory judgment that his remarks and writings about the former First Lady are not defamatory, essentially, a court-sanctioned victory in advance of any libel action Melania might pursue. But U.S. District Judge Mary K. Easkochiel on Friday threw out Wolf's case, calling it a bad faith misuse of New York's anti-SLAPP law and an example of forum shopping. In her sharply worded decision, the judge said Wolf was basically asking for a guarantee that if the First Lady sues him, he deserves to win, which is not how courts operate. The dismissal of Wolf's complaint means that if Melania Trump wants to pursue a defamation claim, she must do so in the usual manner and in a forum of her choosing. For now, Wolf's gambit to short-circuit any potential lawsuit by her has been definitively shut down. Wolf's legal maneuver stemmed from an escalating feud with the Trumps over salacious claims he made in recent interviews and writings. The 69-year-old author, famed for his inside accounts of the Trump White House, had written and spoken about Melania Trump's private life, including insinuations about her social ties to the late sex offender Jeffrey Epstein and allegations that her marriage to Donald Trump is a transactional arrangement. These comments drew a legal threat from Melania's attorney in 2025, warning Wolf to retract his statements and threatening a $50 million defamation lawsuit. Instead of backing down, Wolf sued the First Lady in New York, citing the state's anti-SLAPP law designed to swiftly dismiss baseless suits, to get a court to declare his statements protected by the First Amendment. Judge Easkochiel found this tactic both procedurally improper and a transparent attempt to circumvent the normal judicial process. She noted that defamation cases must begin with an actual plaintiff, in this case, Melania, suing a defendant, not the other way around.